Eleanor May Whitfield. The judge's voice did not rise, it did not tremble, it was simply there, flat, deliberate, and devastating, hanging in the air of courtroom 14 like smoke after a shot has been fired. Nobody moved. Not the defense attorney, whose pen hovered 2 inches above his legal pad frozen mid-sentence. Not the prosecutor, who had already turned halfway toward the jury box before something made her stop. Not the gallery, 23 people who had sat through 4 days of testimony about forged signatures and inheritance disputes. None of them breathed. Because that name was not on the docket. That name was not part of the case. That name, according to every document filed in the matter of Hargrove v. Hargrove Estate, had been dead for 11 years. Let's go back, because to understand why that name shattered a courtroom, you have to understand the case it interrupted and why everyone in that room had already made up their minds before the trial even began. Crestwood Falls, Ohio. Population 41,000, a mid-sized town with good schools, 2 struggling diners, a courthouse that smelled of cedar and old carpet, and the kind of quiet that gets disrupted maybe once every decade by something truly ugly. This was that decade's ugly. The case had started simply enough. On paper, it was an estate dispute. Martin Hargrove, 74 years old, former owner of Hargrove Lumber, a regional business that had operated since 1962, had died 14 months earlier after a short illness. He left behind 2 adult children from his first marriage, a son, Derek, 47, who had managed the company's finances for the past decade, and a daughter, Sonia, 43, who had left Crestwood Falls 20 years ago and rarely returned. He also left behind a will, or rather, he left behind 2 wills. The first will, dated 6 years before his death, divided the estate equally, 50% to Derek, 50% to Sonia. Clean. Simple, the kind of document a family lawyer writes in an afternoon. The second will, the one that arrived 3 weeks after Martin Hargrove's funeral, was different. This will, dated just 8 months before his death, left the entire estate, the business, the property, the accounts totaling just under $4 million, entirely to Derek. Sonia's name did not appear once. Now, here is where it gets interesting. Because Sonia didn't just grieve, she didn't just call a lawyer, she hired a forensic document examiner, drove back to Crestwood Falls, and stood in front of anyone who would listen with a single sentence burned into her eyes. My father did not write that. The forensic examiner agreed. The signature on the second will, she testified during day 1 of the trial, showed micro-tremor inconsistencies incompatible with Martin Hargrove's known handwriting samples from the same time period. The ink composition suggested it had been applied more recently than the paper's stated date. And, most damning, the notary stamp at the bottom of the document belonged to a notary who had retired from practice 18 months before the will was supposedly signed. Derek's attorney, a composed and expensive man named Richard Calder, had an answer for all of it. The tremor inconsistencies were attributable to Martin's declining health. The ink analysis was flawed methodology. And the notary had apparently performed one final informal service for an old friend before officially closing his practice. Calder produced a handwritten note from the notary confirming as much. The jury was listening. The gallery was watching. And Sonia Hargrove sat at the plaintiff's table, with her hands flat on the surface, very still, very quiet, the way a person gets quiet when they've been fighting for so long that stillness is the only thing they have left. That was the case. 4 days of back and forth. Experts versus counter-experts. Documents versus counter-documents. And then Sonia's final statement. It was the morning of day 5. The closing arguments were scheduled for the afternoon. But first, the judge, Honorable Patricia Okafor, 15 years on the bench, known for her economy of words and her absolute intolerance for theatrics, had allowed each party a final opportunity to present any remaining evidence or statements before summations. Derek's team had nothing additional. Richard Calder stood, smiled at the jury with the confidence of a man who knew how the math worked, and sat back down. Sonia stood alone. Her attorney had advised her not to speak. He had told her, gently but firmly, that the forensic evidence was strong enough on its own, that juries responded poorly to emotional testimony from interested parties, and that the best thing she could do for her case was sit quietly and let the facts speak. She thanked him. She straightened her jacket. And she stood up anyway. What she said next lasted approximately 4 minutes. I want you to hear it, because the way it was received in that room is important. She began by talking about her father. Not the businessman, not the estate. The man. She described a specific memory. A Saturday afternoon when she was 11 years old, and her father had driven her 40 miles to a library in Columbus because Crestwood Falls Library didn't carry the books she needed for a school project. She described how he'd waited in the car for 2 hours, reading a newspaper, because the library didn't allow food and he didn't want to leave his coffee thermos in plain sight. She described how, on the drive home, he had told her, "The most important thing a person owns isn't their house or their money. It's their name on a piece of paper. That's the thing that outlasts you." She said her father had told her that. And then she paused. And then she said, and this is the part that matters, she said, "There is a document. I don't have it. I don't know where it is, but I know it exists, because my father told me about it 2 weeks before he died. He said there was something he should have done differently, something he needed to fix, and he said if anything happened to him before he could fix it, I should look for Eleanor." Dead silence. He said her name. He said Eleanor would know. I didn't understand it then. I don't fully understand it now, but I am standing here telling you under oath that my father said that name, and I believe with everything I have that finding Eleanor is the key to understanding what happened to that will. She sat down. There was a pause. Then, from the gallery, someone coughed. Calder turned slightly to his associate and said something in a voice low enough that the microphones didn't catch it, but not so low that Sonia couldn't see the slight smirk pulling at the corner of his mouth. The judge asked if there were any responses to the statement. Calder stood briefly and said, with practiced understatement, "The defense has no response to speculation, Your Honor." A few jurors exchanged glances. One. Juror number 7, a retired schoolteacher named Bernard Crane, wrote something in his notepad. Nobody in that room thought Eleanor was real. Here is what nobody knew about Judge Patricia Okafor that morning. 3 evenings earlier, the evening after day 3 of testimony, she had taken the case files home. This was not unusual for her. She was the kind of judge who read everything twice, who distrusted summaries, and who had a particular habit of cross-referencing witness lists against public records when something in a case felt slightly misaligned, like a picture hung 1 degree off level. Something had been bothering her about the Hargrove case. She couldn't name it specifically. It was the notary note, the handwritten note confirming the final informal service to an old friend. It was competently forged, if it was forged, but there was something in the phrasing. As a final kindness. People don't phrase things that way in informal notes. They say as a favor or to help out. The phrase had the careful quality of a sentence written by someone thinking very hard about what to say. So she had pulled the notary's public record. His name was Harold Voss. 71 years old. Notary public for 32 years. Retired. No disciplinary history. Unremarkable, in every way except for one thing that appeared in his public filings from 11 years ago. A name change application. Harold Voss had legally changed his name 11 years ago. His original name, the name he had practiced under for 21 years before the change, was Harold Whitfield. Whitfield. Judge Okafor had sat in her kitchen at 11:40 p.m. with a cup of tea going cold beside her, and she had stared at that name for a very long time. She had not introduced this finding during the trial. It was not her role to investigate. It was her role to adjudicate. But when she came to court on day 5 and heard Sonia Hargrove stand up and say the name Eleanor, say it without knowing, without any access to the file she had read 3 nights ago, Patricia Okafor felt something move in her chest that had nothing to do with law and everything to do with the oldest, most human instinct in any room where truth is sought. Recognition. She waited until the morning session concluded. She waited through the lunch recess. She waited until the gallery had settled back into their seats and the bailiff had called order and Richard Calder was already relaxed in his chair, already thinking about dinner. And then she opened a folder. And she said, in that same flat, deliberate voice, "Eleanor May Whitfield." I want to stay in that silence for a moment, because what happened in courtroom 14 in the 30 seconds after that name was spoken is one of the most quietly revealing sequences in the entire story. Derek Hargrove, who had sat through 4 days of testimony with the practiced calm of someone accustomed to controlling rooms, went absolutely, completely still. Not the stillness of confusion, not the stillness of someone trying to understand, the stillness of someone who has been standing on ice and has just heard it crack beneath them. His attorney, Richard Calder, turned to look at him. Derek did not turn back. Sonia, on the other side of the room, had her hand over her mouth. Her eyes, which had been dry for 4 days, a deliberate act of composure that her attorney had specifically coached, were no longer dry. Judge Okafor looked up from the folder. She surveyed the room with the patience of someone who understood exactly what she was watching. Then she said, "I am exercising judicial discretion to introduce a public record discovered in the course of case review, which I believe bears direct relevance to the integrity of the documents submitted as evidence. Counsel will approach." Both attorneys stood. They walked to the bench. The gallery watched. Juror number 7, Bernard Crane, stopped writing and looked up. He would later say, in an interview months after the verdict, that the moment the judge read that name, something shifted in the room's atmosphere in a way he couldn't articulate. It was like the air changed temperature, he said. Like everybody in that room suddenly understood that what they'd been watching wasn't the real story. He was right. What they had been watching wasn't the real story. The real story had begun 11 years ago. And it had a woman at its center who had died, or who everyone believed had died, in a hospice in rural Pennsylvania while her family, scattered and complicated and full of the kind of love that becomes indistinguishable from grief, had said their goodbyes and gone home. Eleanor May Whitfield was 73 years old. She was born in Crestwood Falls. She had grown up 3 streets away from where Martin Hargrove's family had lived. They had attended the same high school. They had danced at the same homecoming. They had, and this is the part the record shows, even if it shows it only in the careful, bureaucratic language of legal filings, they had, for approximately 2 years in their early 20s, been engaged. The engagement ended. The reasons were not public. People who remembered them in those years gave different accounts. One said it was a family disagreement over property. Another said Eleanor had wanted to leave Ohio and Martin had refused. A third, an elderly woman named Ruth Calloway, who had been Eleanor's closest friend for 30 years, said. simply that it was complicated in the way that things are complicated when you love someone and the world doesn't cooperate. Martin Hargrove married someone else, had his children, built his business. Eleanor Whitfield moved to Pennsylvania, became a schoolteacher, never married, and maintained, according to Ruth Calloway, a single ritual for the rest of her life. A letter. One letter, every year, to Martin Hargrove, never sent through any address that could be easily found, always through an intermediary. For 50 years. Martin Hargrove received those letters. He kept every one. And here is the thing that changes the entire shape of what you've been watching. Eleanor Whitfield was not dead. The rumor of her death had spread through Crestwood Falls 11 years ago when Harold Voss, then Harold Whitfield, Eleanor's younger brother, had filed paperwork related to a medical power of attorney. The paperwork had been misread. A clerk had made an administrative note. The note had become a local assumption, and nobody had corrected it. Because Eleanor was not present, Harold had moved away, and the dead, as anyone who has lived in a small town knows, are easier to leave alone than to resurrect. Eleanor May Whitfield was alive, in a small apartment in Lancaster, Pennsylvania, at the age of 73, with a plastic folder in her closet that she had been carrying from apartment to apartment for 6 years, waiting for someone to ask. Martin Hargrove had asked. Not directly. Not in time. But he had asked. Here is what was in the folder. A letter. Handwritten by Martin Hargrove, dated 14 months before his death, 3 months before the second will was supposedly signed. Addressed, in his own unmistakable handwriting, the same handwriting the forensic examiner had analyzed, the same handwriting whose characteristics she had spent 2 days explaining to a jury, to Eleanor. The letter was 7 pages long. Judge Okafor did not read all 7 pages into the record. She read 3 paragraphs. I will tell you what those paragraphs contained, because they are the spine of everything. In the first paragraph, Martin Hargrove told Eleanor that he had been diagnosed with a progressive illness, that he had at most 18 months, that he was writing to her, specifically to her, because there were things he had never told his children, things he had been carrying for decades, and he needed someone who knew him completely and would not flinch. In the second paragraph, he told her about Derek. He told her that 3 years earlier, he had discovered that Derek had been systematically redirecting funds from the business, not stealing, precisely, but restructuring accounts in ways that made Martin a minority stakeholder in his own company through a series of subsidiary transfers that Martin had signed without fully understanding their implications, that when Martin had confronted Derek, Derek had initially apologized, and then, 6 months later, had presented Martin with a revised document, a new internal business agreement, and asked him to sign it. Martin had signed it. He had signed it because he was 69 years old and tired, because Derek was his son, because the language was impenetrable, and because he did not, at that moment, understand what he was signing. He understood later. In the third paragraph, and this is the paragraph that silenced Courtroom 14 in a way that went beyond ordinary quiet, the way a room goes silent when something irreversible has been said, Martin Hargrove wrote, I made a second will. I made it because I was frightened, and because Derek asked me to, and because I did not have the courage to tell him that I knew what he had done. I signed documents I should not have signed. But I want you to know, I want someone who remembers who I was to know, that the man who signed those things was not the man who taught his daughter that a name on paper is the thing that outlasts you. I don't know how to undo it. I don't know if I have time to undo it. But if Sonia ever asks, if she ever fights, tell her that her father knew. And tell her, I'm sorry I wasn't brave enough sooner. There are moments in courtrooms that lawyers train for, moments they anticipate, prepare responses to, rehearse counters against. Richard Calder was a very good lawyer. He had prepared for a great many things. He had not prepared for this. When Judge Okafor finished reading the third paragraph, Calder sat for 3 seconds without moving. In those 3 seconds, something happened to his face, not a collapse, not a visible crack, but a microscopic recalibration. The way a person's expression shifts when they have been calculating a sum and realize they made an error on the first line. Everything they built after that is wrong. Everything has to be rebuilt. He asked for a recess. The judge granted 20 minutes. Derek Hargrove and Richard Calder left through the side door. The gallery erupted into quiet, urgent conversation, the kind that sounds like a single low hum from a distance. Sonia sat at her table and did not speak. Her attorney leaned close and said something to her. She nodded once, slowly, the nod of someone who has been told they were right so many times without effect that being told they were right again, finally, in a room full of people, it doesn't feel triumphant. It feels exhausting. Bernard Crane, Juror 7, later described those 20 minutes in the jury waiting room as the strangest of the entire trial. Nobody talked, he said. We all just sat there. Some people were looking at their hands. I think we all knew. We'd known for a while, maybe. But knowing it formally, having the judge say it, it's different. It becomes real in a different way. The recess ended. Derek Hargrove came back into the room looking like a man who had aged slightly in 20 minutes, still composed, still upright, but something structural had gone from his bearing, the invisible architecture that holds a person in a performance of themselves. What emerged over the next hour, as the judge guided both attorneys through the implications of the newly submitted evidence, was a timeline. And timelines in cases like this are not just legal tools. They are the X-ray of intent, the image that shows what was broken and when the breaking happened. Derek had first requested the second will approximately 18 months before his father's death, 2 months after Martin confronted him about the account restructuring. At that point, Martin had not yet drafted it. The request had been made through a conversation, a pressure. The kind of sustained, gentle pressure that families can apply without ever raising their voices or using direct language. The notary, Harold Voss, formerly Harold Whitfield, had been approached separately. Here is where it becomes precise. Harold Voss was not a willing conspirator. He was a frightened man. His sister Eleanor had a complicated medical history. She was not dead, but she had been ill. And Derek had done his research. He had discovered through sources that have never been fully clarified that Harold had a connection to Eleanor, that Eleanor had a connection to Martin, and that Harold would very much prefer that his family's history remain private. It was not blackmail in the legal sense. It was quieter than that. It was the kind of pressure that leaves no fingerprints, that operates entirely through implication, that says, I know things. And I would prefer that those things stay between us. Harold Voss had notarized a document he should not have notarized. He had written a confirming letter he should not have written, and then he had changed his name, not to hide from the law, but to put distance between himself and a chapter of his life that he was ashamed of, the way people sometimes try to rename themselves when they cannot change what they did. He had not known, until the day Judge Okafor found his original name, that the distance had not been enough. There is a detail in this story that I have been holding back, not to deceive you, but because the sequence in which you understand things matters to the sequence in which this story becomes real. Eleanor Whitfield did not appear in that courtroom by chance. 2 days before day 5 of the trial, 2 days before Sonia stood up and said the name, Eleanor had made a phone call. She had called the Crestwood Falls courthouse. She had asked, very politely, whether the Hargrove estate case was still ongoing. She had been told it was. She had asked whether there was a way to submit additional evidence. The clerk had taken her name and number and said someone would call her back. Nobody had called her back. This happens, in the bureaucracy of overworked courtrooms, more often than anyone would like to admit. A note gets taken. The note sits on a desk. The desk has 17 other notes on it. The case moves forward. Eleanor had waited. She had the patience of a woman who had been waiting, in one form or another, for decades. She had the plastic folder on her kitchen table. She had Martin's letter. She had a second document that she had never told anyone about, not even Ruth Calloway. A document that Martin had signed in her presence, in Lancaster. During a visit 3 years before his death, a notarized codicil to his first will, the equal division will, affirming its validity and signed by 2 witnesses whose names and contact information were still current. Eleanor had driven to the courthouse the morning of day 5. She had arrived at 8:47 a.m. The session began at 9:30. She had asked to speak with someone, anyone, about the case. She had been told to wait. She had waited in a chair in the lobby, a 73-year-old woman in a gray coat with a plastic folder on her lap, watching people walk past her with the focused busyness of people who have places to be. At 9:22, 8 minutes before the session opened, a court clerk, a young woman named Dana Reyes, 3 months into the job, who would later say she acted on nothing more than the feeling that the woman in the gray coat looked like she mattered, Dana Reyes had stopped and asked if she could help. Eleanor had shown her the letter. Dana had read 3 lines. And then Dana had done something that more experienced clerks, more accustomed to procedure, might not have done. She had walked directly to the judge's chamber and knocked on the door. Judge Okafor had been reviewing her notes on Harold Voss. She had looked up. She had read the letter, all 7 pages, in 11 minutes, and at 9:30 a.m. she had walked into courtroom 14. The second document in Eleanor's plastic folder was, in legal terms, the kill shot. A codicil, a formal amendment to an existing will, is only valid if it meets specific requirements. It must be signed, witnessed, and notarized. It must explicitly reference the original will, and it must be executed with the same mental capacity and voluntary intent as the original document. Martin Hargrove's codicil met every requirement. It was signed in Lancaster, Pennsylvania, in Eleanor Whitfield's living room, in the presence of 2 witnesses, Ruth Calloway, yes, the same Ruth Calloway, and a neighbor named Gregory Park, who had no connection to the Hargrove family and no stake in the outcome. It was notarized by a licensed notary in Lancaster, whose practice was active and current. And it was dated 11 months before Martin's death, 3 months after the date on Derek's supposedly signed second will. Read that again. The codicil was dated 3 months after the fraudulent second will. This meant one of 2 things, and only 2 things were possible. Either Martin Hargrove had knowingly reaffirmed his original equal division will after having supposedly signed the version that cut Sonia out entirely, which would mean he had second thoughts, recanted his decision, and left evidence of doing so. Or, and this was the option that Richard Calder's face, when the codicil was entered into evidence, confirmed without him saying a single word, the second will had been forged after Martin's death, backdated to appear earlier than it was, and the codicil's existence proved that Martin's actual, documented final wishes contradicted everything Derek had filed. The codicil was not ambiguous. It read, in part, I affirm that the will executed on the 14th of March, dividing my estate equally between my children Derek Hargrove and Sonia Hargrove, represents my complete and final wishes, and that no subsequent document purporting to alter this division has been executed by me, voluntarily or with full understanding of its contents. Martin Hargrove had seen what was coming. He had not been fast enough to stop it entirely. But he had left a key under the mat, in a city nobody thought to look, with a woman nobody believed was real. Testimony was suspended for the remainder of day 5. The judge called an emergency session in chambers. Both attorneys were present. The codicil was authenticated on the spot using the two witnesses, both of whom were reachable by phone within 40 minutes. Gregory Park answered on the second ring. Ruth Calloway, at 81 years old, gave her confirmation in a voice that trembled not with uncertainty, but with the particular trembling of someone who has been holding something in for a very long time. Derek Hargrove sat in the courtroom while his attorney was in chambers. He sat with his hands on the table, looking at nothing specific. A court deputy sat in the row behind him. The gallery had mostly emptied at the judge's direction. A few journalists remained, understanding instinctively that they were watching something important even before they fully understood what it was. Derek did not weep. He did not speak. He did not do any of the things that people in films do when their plans collapse. He simply reduced. It's the best word for what happened. He became smaller, not physically, but in the invisible way that people become smaller when the performance falls away and what remains is just a person in a room. Accountable. He had spent months constructing a version of events that was plausible, documented, defended. He had hired expensive people to protect that construction. And in the space of 90 minutes, the construction had come apart, not through brilliant lawyering, not through forensic genius, but through a 73-year-old woman in a gray coat who had made a phone call, waited in a chair, and kept a letter. Sonia Hargrove came back into the courtroom at 3:15 p.m. She sat down at her table. She looked at her brother across the room. He did not look back. Later, much later, after the verdict, after the appeals process, after everything had settled into the permanent record, a reporter asked Sonia what she was thinking in that moment. "I was thinking about the drive to Columbus," she said. "The library, my father waiting in the car. I kept thinking about that, the whole trial. I kept thinking, he was right. It's the name on the paper. That's the thing that outlasts you." And he made sure it did. There is a question that had gone unasked through the entire trial, and I want to address it now because it is the kind of question that feels uncomfortable, but is also the question that explains everything. Why hadn't Sonia known about Eleanor? Why had Martin kept this relationship, 50 years of letters, a visit to Lancaster, a codicil signed in her living room, entirely invisible? The answer, when Eleanor gave it in a deposition 6 weeks after the trial's end, was simpler than the mystery that surrounded it. "He was protecting me," she said. He knew what Derek had become. He knew that anyone connected to him, anyone he'd asked to witness documents or keep letters, could become a target. He was an old man who had made mistakes and was trying, very late, to fix them. He didn't want to involve me more than he had to. He asked me to keep the letter and the codicil safe. He said, "Don't come unless you have to. Don't call unless you have to. But if Sonia asks for Eleanor, go." She paused in the deposition. The attorney waited. "She didn't call me. She said my name in a courtroom and I was already in the building." Derek Hargrove's attorney, Richard Calder, withdrew from the case the following morning. This is not unusual when a case turns the way this one turned. Attorneys have professional obligations that make representation of a client whose strategy has collapsed into potential criminal territory a very different proposition than representing a client in a civil dispute. Derek hired new counsel. It did not help. The civil case resolved within 3 weeks. The fraudulent second will was invalidated. The original equal division will was upheld. Sonia Hargrove received her 50% of the estate, the business, the property, the accounts. After legal fees and the costs of the 2-year battle that had preceded the trial, her share was reduced from its theoretical value, but it remained, as her attorney put it, substantial and, more importantly, right. The criminal dimension moved more slowly, as criminal matters do. The forgery of a will in Ohio is a felony. The coercion of a notary, even through implication, even without explicit threats, entered the case with the addition of Harold Voss's own testimony, which he gave willingly, perhaps even with relief, the way people who have been carrying something heavy describe the moment they set it down. His cooperation with prosecutors was noted. His own exposure was managed accordingly. Derek Hargrove was indicted 6 months after the civil verdict. The charges included forgery, fraud, and 2 counts related to the financial restructuring of Hargrove Lumber, the account transfers that Martin had described in his letter to Eleanor, which investigators, once pointed in the right direction, found meticulously documented in the company's own records, because Derek, despite everything, had been a careful accountant, and careful accountants leave trails. He pled not guilty. Then, 14 months later, he pled guilty to reduced charges in exchange for cooperation. He was sentenced to 4 years. Served 2.5. Hargrove Lumber, the company that Martin had built over 40 years, that Derek had been systematically undermining for 3, and that Sonia had never wanted to run, was sold. The buyer was a regional competitor who had watched the case with considerable interest. The sale price was fair. The employees kept their jobs. The cedar smell of courtroom 14 is still there, if you visit. The carpet is still old. The chairs are still arranged in the same configuration. There is no marker, no plaque, nothing to indicate that anything out of the ordinary happened there. But if you ask Dana Reyes, the clerk who stopped and asked if she could help, she will tell you that she thinks about that morning sometimes. About a woman in a gray coat who had come all the way from Lancaster. About the folder on her lap. About the way she looked up when Dana approached her, with the particular expression of someone who had been waiting for a very long time to be seen. She didn't seem surprised that I stopped, Dana said. She just said, "Thank you. I was starting to wonder." And she opened the folder. There is a version of this story where none of it works out, where the phone call Eleanor made is never followed up on, because it isn't, and the session proceeds, and the forensic evidence, strong as it was, isn't quite enough, and the jury deliberates for 3 days and comes back with a split verdict, and Sonia appeals, and the appeals process takes 4 years, and by the time anything is resolved, the estate has spent most of its value on legal costs, and Derek manages the business into the ground anyway, and Martin Hargrove's name on a piece of paper means nothing, because the pieces of paper are all wrong. That version is a hair's breadth away from the version that happened. What changed it was not a dramatic revelation or a brilliant strategy. What changed it was a 73-year-old woman who drove 3 hours to a courthouse and waited in a chair. What changed it was a 24-year-old clerk who broke from procedure because something told her not to walk past. What changed it was a judge who took files home and read them twice and noticed a phrasing that felt wrong. And underneath all of it, the foundation on which every piece of it rested, was a dying man who had made mistakes, who knew he was out of time, who could not fix everything, but who could write a letter, who could visit a woman he had loved for 50 years and ask her, quietly, to hold something for him. Don't come unless you have to. He knew his children. He knew Derek's capability. He knew the ruthlessness that had grown inside his son over years of proximity to money and power. He had watched it happen and had not stopped it soon enough, the way parents sometimes love their children's potential so fiercely that they do not see until very late what that potential has become. But he knew his daughter too. He knew she would come back. He knew she would fight. He knew that if he gave her something real to point toward, she would not stop pointing until someone listened. He also knew, in the way that people know things about their own families that they never say aloud, that she might stand in a courtroom and say a name, not knowing whether anyone would hear it, because that was who Sonia was. The kind of person who says the true thing even when it costs her. He had told her, once driving home from a library in Columbus, that the most important thing a person owns is their name on a piece of paper. He had put his name on the right piece of paper, and it had outlasted him. I want to end with Eleanor. Not with the verdict or the sentencing or the sale of the company, because those are the conclusions of a legal story, and this was never just a legal story. 12 months after the trial, a local journalist named Carrie O'Duya drove to Lancaster to interview Eleanor Whitfield. She found her in a small apartment, well kept, with photographs on a shelf and a window that looked out over a garden that wasn't hers, but that she could see from her chair. She was not a dramatic figure. She was a former schoolteacher with a considered way of speaking and a precise habit of pausing before she answered difficult questions. She had, by that point, spoken with Sonia several times, by phone and in person once, over coffee in a diner between Crestwood Falls and Lancaster, halfway between where they both were. She told Carrie O'Duya that she did not think of herself as having saved anything. She said she had simply kept what she was asked to keep. She said that the hardest part had not been the decades of waiting, but the weeks after the trial, after the verdict, after her name had appeared in several news articles that described her variously as the woman who changed the verdict, the mystery witness, and once, memorably, as a ghost. From the past. "I'm not a ghost," she said, with a slight smile that suggested she found it more amusing than annoying. "I'm a retired schoolteacher from Lancaster. I had a folder. I kept the folder. That's the whole story." Carrie O'Duya asked if she regretted any of it. The 50 years of letters. The secrecy. The long separation from someone she had once expected to build a life with. Eleanor looked out the window at the garden for a moment. "You know what he told me, that last time I saw him? He said, 'Eleanor, I think I did everything wrong in the wrong order.' And I said, 'Martin, you fixed what you could when you could.' And he said," she paused. "He said, 'I hope it's enough.'" She turned back from the window. "It was," she said. "It was enough. There is something that stays with me about this case. Not the legal mechanics, those are important, but they're not what haunts you. What stays with me is the image of a man at the end of his life writing 7 pages to someone he had loved since he was 22 years old, asking her to hold a truth he was too afraid and too late to deliver himself. And the truth held. It held through an administrative error and a name change and a decade of quiet and a missed phone call and a chair in a lobby, right up until an ordinary court clerk asked if she could help, and a woman in a gray coat said yes, actually, and opened a folder. I want to ask you 3 things before you go. First, if you were Sonia, standing up to speak when your own attorney told you not to, knowing you might be dismissed, mocked, written off, would you have done it? Or would you have stayed in your seat? Second, Martin Hargrove had 18 months after his diagnosis. He used some of that time to fix what he could, and he didn't fix all of it. Do you think he made the right choices with the time he had? Or do you think there was more he should have, could have, done sooner? And third, there is a version of this story in almost every family. A document kept somewhere. A name that holds a key. A truth that nobody asked for because nobody knew to ask. Is there something like that in yours? Think about that. And if you want to go deeper into cases where one overlooked document changed everything, where the truth was in the file the entire time, waiting for someone to read it twice, I have another case waiting for you. It involves a real estate deed, a church in rural Georgia, and a signature that 3 lawyers missed for 20 years. Hit the video in the corner. It's already queued.